Okay, folks, good morning. Let's get started. In this video topic, I'm going to talk about the basics of conspiracy. I'll briefly sketch the typical elements for conspiracy, both the Actus Reus and the mens rea, but we'll save for class discussion a detailed coverage of the very complicated mens rea rules here for conspiracy. I'll also summarize for you the procedural advantages that make this charge so popular with prosecutors and the various scope limitations that some jurisdictions place on the reach of conspiracy crimes. Now, running throughout this discussion about the reach of conspiracy is this question: should we treat conspiracy as an inchoate crime, that is, a way of reaching criminal behavior before it reaches its conclusion, before it's completed, much like a super attempt law, or at least a group attempt law? Or should we instead treat conspiracy as a way to punish the extra danger that is involved when groups get involved in criminality, so that it's not just an early punishment of crime, but it's an extra punishment of crime? We'll be visiting those questions along the way. Let's jump in. So what are the objective elements, the actus reus elements of conspiracy? Well, at common law, and mostly under the model penal code, you've got two different components. First of all, you need an agreement. You have to have parties agreeing. Now, they don't have to say the words, "I hereby agree to commit a crime," but there has to be some evidence from whatever source, spoken, written, implicit in actions. There has to be, ultimately, the jury has to believe there was an agreement between two different parties that at least one of them would commit a crime. Second, in almost all jurisdictions, you need an overt act that at least one of the members of the conspiracy performs. But for this overt act, notice it can be a tiny little something. It could be something that is as perfectly legal as going to the store and buying duct tape for the kidnapping. In that situation, you might be able to intervene earlier in a conspiracy than you would with an attempt. So it can be something that might amount to mere preparation if we were analyzing the situation under attempt law. So something very minor can qualify as the overt act, but you got to do something that is in furtherance of this conspiracy. The act must carry the agreement along in some way. Next, what are the culpability elements of conspiracy? The mens rea of conspiracy. It's complicated. We have different rules at common law and in modern codes here embodied in the model penal code, but let's step through them briefly. First of all, for conduct elements of the underlying completed crime, both the common law and the modern codes, including the model penal code, elevate that underlying intent to purpose. You have to have the purpose to carry out the conduct that is embodied in the underlying offense. As for result elements of the substantive offense, under the common law and the modern codes, including the model penal code, again, you elevate to purposeful, although this is not a universal rule. For instance, in the federal system, your text cites to a case, United States versus Fiola, and this case says in the federal system that you don't elevate, that you use the whatever is the underlying mens rea listed in the statute for the substantive offense element, if it's a result element. And then finally, for circumstance elements of the substantive offense, at common law, typically you elevate to purposeful here as well. Although again, there are some exceptions, like the federal courts don't elevate the mens rea for circumstance elements. On the other hand, the model penal code and a number of modern codes say that that for circumstance elements, maybe you don't elevate. Under the model penal code, the commentary says that we're going to leave that to interpretation of the courts. They were kind of ambivalent about what to do about it. An example of the elevation principle in operation is State versus Beccia. I love that for a good Italian Connecticut case, State versus Beccia, 1986 case. The owner of the Night Owl Cafe Club was at the trial convicted of conspiracy to commit third-degree arson. and that's a crime that involves recklessly damaging a building by intentionally starting a fire. Basically, Betcha had agreed with another party to start a fire, and they were aware of a risk of damage to the building. The opinion doesn't really say why they agreed to start a fire. I'm thinking maybe pyrotechnics at a rock show at the club or something. We don't know. But at any rate, the appellate court says you can't convict him of conspiracy to commit arson here because you can't get the relevant mens rea. Of course, yes, they agreed to start the fire, but there's also the element of recklessly being aware of the risk of damage to the building. If you're convicting him of conspiracy to commit arson, that reckless awareness of damage to the building has to bump up to purpose to damage the building, and the court says you didn't have proof of that. Sometimes conspiracy law is called the darling of the prosecutor's nursery, that is the favorite child. Why do prosecutors love this charge so much? It gives them some important procedural advantages. First of all, if you're trying conspirators, you can try them all together in one trial. That is normally a procedural advantage for the government. The jury hears about all the wrongdoing, all the completed crimes, all the agreed upon crimes, all in one big package, and you don't end up slicing it so fine as to each individual defendant. The prosecution also gets some advantages for venue. That is, you can bring the charge in any court where any one of the agreement or any one of the overt acts happened. And so you might have one particular jurisdiction that's unfavorable. The jury you just don't think is going to be sympathetic, but at another place they might really buy your case. And so you get some choice about which jury you're going to try the case in front of. And then finally, there are some evidentiary advantages that I won't go into in detail here, but it helps under the hearsay rule. You end up bringing in some statements from the co-conspirators that might otherwise be excluded if you were trying people all separately without any conspiracy involved. Now, for one of the scope limitations, let's return to the Actus Reus for a conspiracy, what you have to do. Remember, there has to be an agreement. What if the agreement's phony? What if, for instance, I'm negotiating a sale of something illegal, let's say drugs, but the person I'm negotiating with is a government agent who has no intention of carrying out the transaction in reality? If we've got a phony agreement, is that enough for a conspiracy? Jurisdictions that follow a rule called bilateral agreement would say that's not a conspiracy if you're conspiring with a government agent who's not really in the game. You have to have both sides, a bilateral agreement. At least two people out of the group, maybe not everybody, but at least two people out of the group really have to mean it when they enter the agreement. On the other hand, there are unilateral jurisdictions, and the model penal code moved to a unilateral view of conspiracies. In this world, all it takes is for this defendant to believe that there was an agreement, even if the others were not authentically in the game. This is, as always, a way for the model penal code and a lot of other modern statutory codes to emphasize state of mind, to say we don't care what really was going to happen, what real group danger was going to be involved here. What we care about is that you had this on your mind, you had a blameworthy state of mind as to the alleged agreement, even if it was phony. There's another very important scope question where you'll find differences among jurisdictions. And these relate to the connection between the conspiracy and the completed crime. There are two rules here. First of all, under the common law, as well as in the federal system, it's embodied in the Pinkerton case from 1946, a defendant can be convicted both of the conspiracy and the completed substantive offense. Pinkerton, by the way, was a moonshining case. That's the picture here. And the defendants, one of them was actively engaged in the moonshine business, and the other one had agreed but had done nothing. His argument was, you shouldn't convict me both of the conspiracy and of the completed tax violations that come out of the moonshining activity. But that argument was rejected. You can convict for both under the federal rule and typically under the common law. Second, that extra conviction for the completed offense can happen even if somebody else did it, and even if you didn't agree to that explicitly, even if you don't know your partner's going to commit that crime. If it's in furtherance of the conspiracy, if it helps in some way, then everybody in the conspiracy is on the hook for everybody else's crimes, even the ones that are not an explicit part of the agreement. Now, why would we treat conspiracy as a separate crime punished on top of the completed crime? Well, we call this the group danger rationale, and we say that extra danger comes to the public when a group of people are acting to carry out a crime. There's the classic Adam Smith specialization of labor benefits. There's just more time and resources among all the different members of the group to carry out the crime, so it becomes more likely to occur and to be more effective. If I'm in part of a group and I believe, I might back out, but gosh, the group is counting on me, I'd better go ahead with it. It's just an agreement or a plan that's more likely to happen if it's a plan that goes forward in a group where people are counting on each other. And there's just some social harm to non-group members knowing that there are groups out there operating. That just creates more of a fear, a fear-infested environment, and that is a separate social harm in itself. So for these reasons, the common law pursues these Pinkerton-like rules and says we're going to punish both the underlying offense or the completed offense as well as the conspiracy as an extra harm. The Model Penal Code and a number of more elemental jurisdictions treat conspiracy instead more as a super attempt or a group attempt crime, where you're just trying to get early access once somebody has indicated what's on their mind, but you're not trying to hit them twice. You're not indicating that it's a worse crime, just that you want to move earlier. So here's one last scope question about conspiracies that I want you to think about. How big does the conspiracy get? If I've got a bunch of different people in more or less the same business, a few of them work together, maybe others don't, are they all one big conspiracy? This matters because if we're all in one big conspiracy, then all of the crimes that everybody commits fall back on me as one of the conspirators. On the other hand, if we're in separate conspiracies, then only the people in my corner of the world, only the people in my conspiracy can commit crimes that I will be responsible for. We answer this question by talking about chains on one hand or hub and spoke wheel arrangements on the other hand. Let's talk first about chains. Imagine that A conspires with B conspires with C conspires with D. They're all working together. Maybe it's a distribution chain for distributing an illegal product or service, prostitution, drugs. And the street level dealer knows that there's a supplier above him, and she knows that there's some larger regional distributor above her, and so forth. Maybe A has never met C, or maybe A has never met D. But as long as A knows that C and D exist, then you're in a chain conspiracy, even though they've never met together in the same room and shaken hands and literally agreed at the same time and same place. One conspiracy, a chain. Now let's talk about hubs and spokes. You could have an arrangement where there's one distributor who sends stuff to Chicago, and then the same distributor sends something to a different group of sellers in Boston and a different group in Los Angeles and so forth. If Boston and Chicago and Los Angeles don't ever deal with each other, don't really benefit from having a large organization operating this way, then we could end up concluding, or courts might end up later on saying, that those are separate conspiracies. They have one overlapping member, the hub, but they don't deal with each other, don't benefit from each other. In that situation, only the crimes for each of the spokes are attributed to the people within that conspiracy, and those are the agreements that they're punished for the conspiracy itself. Think about this one other thing. In a hub and spoke arrangement, you could have a chain as one or more of the spokes, so you can combine these concepts. All right, next time we get together, we're going to jump in and talk about the objective elements first, and then we're going to practice with some of the tougher culpability elements. So, see you then.